appropriate, I would be interested to know what media outlets are with us today during this executive session.
I think that's just fine. Do we know Executive Director Myers?
So, Equestrian Media is here. I believe Statesman Journal is here in the room. And then Stephanie.
The Oregon Capitol Chronicle, Julia Shumway, is online. I'm also Justin Alderman with the Equestrian Media Group is trying to access online. Lauren Drake, will be online in just a moment, and with the Oregonian, or with OPB, excuse me, and Carlos Fuentes with the Oregonian.
Thank you, Director Myers and Mr. Chair.
Thank you. Commissioner Payne, can you hear us now? We can see you. Can you say something to make sure we can hear you?
Yeah, I apologize for my lateness. I was having trouble getting back into my office. My code wasn't working. I went to use the restroom really quick and couldn't get back. So I'm here now. I hope you can hear me. I can hear you.
Perfect. We can see and hear you just fine. Thank you. All right, so we'll start with agenda item 85. Let me make sure we're all good to go.
Only media is in the room.
Okay. We'll start with agenda number 85, and who is not appearing. And this is the executive session consent calendar. And knowing that, Vice Chair Fiscom, I'll take a motion.
Mr. Chair, I'm happy to make a motion. Do we need executive director to have a quick report on this or not? And
we don't need a substantive report. These are 3 complaints that were filed that did not meet mandatory prerequisites for public meeting law complaints.
Thank you, Executive. Mr. Chair, I hereby move approval of the consent calendar for the executive session meeting dated June 28, 2024.
Thank you. Any comments? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. We'll now go to agenda item 86 regarding respondent Tiffany Quintero, and she'll be attending by Teams. Hello, Ms. Quintero. My name is Sean Lindsay. Am I saying your name correctly?
Yes, Quintero. Yes. Thank you.
Quintero. Okay.
Chair
Thank you.
Lindsay.
Welcome. Welcome. We appreciate you being with us today. Now's the time to have your matter heard before us. What's going to happen is Investigator Pacheco is going to report on it, and then commissioners will have an opportunity to ask him questions, and you'll also have an opportunity to speak. We do ask that you be brief and to the point, and we may have some questions for you as well, and then we'll decide what to do after that. So with that said, Investigator Pacheco.
Thank you, Chair Lindsay and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 86 in your meeting book is a preliminary review report for Tiffany Quintero, a volunteer assistant equestrian coach at the Ridgeview High School. The complainant in this case, April Posel, alleges that Ms. Quintero used her official position to have a Ridgeview student, who is also the daughter of Ms. Posel, do chores for Ms. Quintero without compensating her. In response, Ms. Quintero stated that she had attempted to pay Ms. Posel's daughter for the chores, but stated that she had declined. In this case, commission staff acknowledged that there appears to be a power dynamic involved in this matter between Ms. Quintero in her role as the equestrian coach and Ms. Posel's daughter as a student. Based on the information gathered, it appears that Ms. Quintero communicated via text with Ms. Posel's daughter to inform her on equestrian-related events, trained Ms. Posel's daughter at her home, and coordinated care for her barn and animals. While Ms. Quintero does not dispute that she messaged Ms. Posel's daughter for assistance, she asserts she did so as a friend. Per ORS 244.040 sub 1, a public official may not use their position to obtain a financial gain or avoid a financial detriment that would not otherwise be available. In this case, the facts establish that Ms. Quintero avoided a financial detriment by having Ms. Posel's daughter provide free care for her barn and animals. However, commission staff do note an additional consideration, in particular 040 sub 2 sub F, which states that it is not prohibited use of position to accept the gift from a source that could not have a legislative or administrative interest. In this case, The unpaid chores that Ms. Polzel's daughter completed for Ms. Quintero's barn and animals could qualify as a gift. Commission staff did not have sufficient information during this preliminary review to make that determination. Should this case move to investigation, commission staff would seek to determine whether the decisions Ms. Quintero makes as the assistant equestrian coach, such as providing instruction and training, could have a distinct economic impact on Ms. Polzel's daughter, such that Ms. Quintero's actions fall within the exception of 040 sub 2 sub F. Based on the information collected in this preliminary review, there appears to be a substantial objective basis to believe that Tiffany Quintero may have violated government ethics laws. The recommendation in your books is to move this case to investigation. Thank you.
Thank you. Investigator Pacheco, who would you intend to speak with about that or verify or?
It would be Ms. Quintero for that. Kind of learn more about the what sort of decisions she could make, and that would have that economic impact on Ms. Polzel's daughter. So learn more about her role and what she provides in terms of the training and the instruction and the economic value of that.
Thank you. Commissioners, any question of Investigator Pacheco? Seeing none, Ms. Quintero, now's your opportunity to respond, and we look forward to hearing from you.
Thank you, Chair Lindsay, Vice Chair Fiscum, and members of the commission. My name is Tiffany Quintero, and I was previously a volunteer assistant coach for the Ridgeview Oregon High School equestrian team in Redmond. I resigned effective Sunday, May 12th this year. Please consider my supplemental response that Mr. Pacheco indicated is included in your materials. It was submitted within the 60 days of the complaint, but upon submission, I learned that the report was already complete. I did not receive financial benefit, and I don't believe I avoided financial detriment by having Ms. Polzel's daughter assist with my animals. I did have others that I would have reached out to that could have done so for free, and upon indication of her not being able to do so, to not be able to help me, I did reach out to others, and I was able to have others help me. It's typical in our horse world to help each other out and return the favors when possible. I don't have a business with my horses or with my property. As a volunteer assistant coach, I did not have authority to make any decisions regarding the team or its student athletes. Specifically, I did not have authority to make decisions that could have had a distinct economic impact on Ms. Polzel's daughter. There are no cash awards. Thank you for the opportunity to provide this statement. I do understand the ethics rules, and I do understand where I erred. This is an incredibly unfortunate and sad situation. I hope you will consider dismissing the matter.
Thank you for your appearance. Thank you. I had a question for you. Do you know this Miss Polzel outside of the school relationship?
No, we are not friends outside of the school relationship.
And
I didn't. I'm sorry. Were you talking about Miss Polzel or Miss Polzel's daughter?
Miss Polzel's daughter.
I apologize. I do know her outside of the school relationship. We were barrel racing together.
Thank you. Commissioners, any questions of Ms. Quintero? Vice Chair Fiscum.
Mr. Chair, this is not a question for our witness. Thank you, by the way, for being here and appreciate your testimony. This is for our executive. I'm going to try to phrase this precisely, but you'll understand my question, I think, if I fail. Ms. Quintero has said that she submitted a document to us, the one that we read, in a timely fashion relative to 60 days, but it wasn't timely in the sense of being included in Mr. Pacheco's investigation. Can you summarize that, the implication of that for us?
So, as you know, we have 60 days. Ms. Quintero did submit she had worked with Daniel and submitted response and then submitted a supplemental response. But at that point, the report had already been sent to DOJ and reviewed by DOJ and signed by me. And under our policies, once preliminary report gets signed by the director, the preliminary review phase is over. So Daniel cannot amend the report. However, we did include it in the Google Drive, and it was sent to all of you.
Right.
You all are welcome to consider the information in the supplemental material.
Thank you. So the implication, Mr. Chair, just one quick follow-up. The implication of that comment, which I appreciate, is that if you sign off on the review report before the end of 60 days, that concludes it, even if it is fewer than 60 days.
Correct.
And I appreciate that comment. Thank you very much.
I had a question for staff, and I'm not sure who would be the best one to answer that. And that is, I understand the gift exception, but I'm also wondering, isn't there another exception on if you have a relationship besides the public official relationship, a standalone separate friend relationship? Is there an exception for that?
There is not an exception for friends. There's an exception for accepting gifts from family. There is exception O, which is usual and customary practice.
Right.
That tends to be a little more focused on like of a business where the business ordinarily provides fancy Christmas gift baskets. So you could accept those as long as it's the usual practice and not tied to your position.
Yeah, thank you. Okay, Commissioner Mason, I see your hand is raised.
Thank you, Chair Lindsay. This was a question for the witness, Ms. Quintero. Did you resign your official position as the assistant coach due to this complaint?
I resigned my, I'm sorry, Commissioner, Chair Lindsay, Vice Chair Fiscum. I resigned my position partially because of the emotional and mental turmoil this created for me, and I didn't feel like I could serve them any longer in this. And I have a very busy family life as well, and so it just didn't feel like I could provide for the students any longer.
I guess my follow-up question, if you don't mind, were you asked to resign or was this voluntary?
I was asked to resign due to a different issue. I was asked to resign by Ms. Pizzell at the same time when she submitted this ethics complaint. She demanded us resign in a public newspaper.
Okay, thank you for that.
Yeah. Commissioners, any other questions for Ms. Quintero or Investigator Pacheco? Seeing none, I see a couple furrowed brows of not knowing what to do. Are any commissioners prepared to make a motion?
Mr. Chair, I'm in my normal role of the maker of motions. I'm happy to recede to colleagues in case anybody has a motion to make. If not, I'll be prepared to make one to see how it flies, frankly.
Okay.
So I'll yield for just a moment to my colleagues.
Go ahead.
Mr. Chair, I'm tempted to make a motion to dismiss this based on the usual and customary discussion we just heard from Executive Director Myers, I'm sorry. In the fact that, I understand in the comment in the horse community of helping each other out bears some weight with me. And so I'm not sure there's anything to be gained by proceeding in this. So I'm prepared to make a motion to dismiss, or if you are so.
I see Commissioner Mason has raised his hand.
I just want to say I'd support that motion.
Okay. All right. Any other commissioners prepared to make a motion? If seeing none, it looks like Commissioner Thompson has a motion to make.
I was not prepared.
We can see that.
Yeah, and I'm right in front, so everyone can see it.
Oh, two.
Oh, if I can jump in then,
Go ahead,
to provide
Commissioner Newell.
there. Thank you, Chair. I also would support the motion when it comes, in part because the question turning on the legislative or administrative interest, and we received that information from Ms. Quintero about her ability to affect the role of various people on the team. And so with that new information, I would also support the motion to dismiss.
Thank you.
Found my place.
Commissioner Thompson.
Mr. Chair, I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis in believing that Tiffany Quintero has violated provisions of Oregon government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. Commissioners, any comments on the motion before us? Seeing none, we'll call for the vote.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Ms. Quintero, the case has been dismissed and you'll get confirming correspondence for that. We wish you a great weekend.
Thank you.
Thank you. All right, we are now going to move to agenda items 87 through 93, who have all waived confidentiality and who will be all attending except for Ms. Moore.
Thank you, Chair Lindsay.
Wait.
Just 1 second, we're going to let them in. Thank you. Investigator Sullivan. Yeah, I'll speak to that in just a second.
We are missing respondent Benko, but everyone else is in the room here.
Okay. Let's see, we should have Miss Kelly, Miss Irving, Miss De Leon, and Miss Clausen. We're looking for Miss Benko, who may or may not be attending.
She was here earlier,
Yeah.
just for the record, before the meeting started, so
Okay.
she may be close.
Yeah, so we're working on getting her. While we're working on getting her, my name is Sean Lindsay. I'm Chair of the Oregon Government Ethics Commission, and now's the opportunity to have your matter heard before us. What's going to happen is Investigator Sullivan is first going to report to the commission on his investigation, and then you will have an opportunity to respond. There's a lot of you responding, and we don't have a ton of time, so we ask that that one of you hopefully would be the spokesperson for the group of you to respond. You all have the right to respond, but it'd be helpful if one of you were designated to be the spokesperson. And we do ask when you do respond that you can be precise and to the point, and so we can have sufficient time to consider your matter fully. And with that said, we have a brand new Investigator Sullivan. Welcome. We appreciate you being with our team, and what a great way to get to know you through an initial investigation. So go ahead, Investigator Sullivan.
Thank you, Chair Lindsay and Commission. I'm Investigator Josh Sullivan for the record. I'm presenting agenda items 87, 88, 89, 91, 92, and 93. Number 90 and 94 are related, but they'll be heard separately. These are complaints against members of the Dallas Middle School Site Council. And the complaint in this case alleges that the members of the Site Council for the Dallas Middle School may have violated ORS 192640 by holding public meetings without proper notice. Under the Public Meetings Law, the TDMS Site Council is a governing body. It's comprised of 2 or more members, and it makes recommendations to the district, a public body, on matters of policy or administration. Under the definition of ORS 162.610.5, it's a governing body subject to the Public Meetings Law. Moreover, the Site Council enabling legislation expressly states Site Councils must comply with Public Meetings Law. Thus, as members of the TDMS Site Council, a governing body, the site councilors are required to comply with the provisions of Oregon Public Meetings Law. ORS 192.640 states the governing body of a public body shall provide for and give public notice reasonably calculated to give actual notice to interested persons, including news media, which have requested notice of the time and place for holding regular meetings. The notice shall also include a list of the principal subjects anticipated to be considered at the meeting, but this requirement shall not limit the ability of a governing body to consider additional subjects. In this case, the TDMS Site Council issued the meeting notices for its February 8th and February 22nd meetings via the TDMS Parent Square Communications platform. Parent Square is only accessible to parents of TDMS students and then only to those parents who register and opt in to receiving notices. Members of the general public cannot register for Parent Square. While there is a community group option in Parent Square, the district's version of Parent Square did not allow community members to sign up for communications on the TDMS Site Council meetings. The TDMS Site Council issuing its meeting notices via Parent Parent Square may satisfy the notice requirement to provide actual notice to specifically interested persons, but it does not satisfy the requirement to provide general notice to the public at large. Essentially, the Parent Square app sent notifications of the meetings, but the settings on the Parent Square group were not set to public. The complainant, Judy Richardson, is on the school district board of directors and one of the parties who approved the posting of the meetings on Parent Square. Meeting notices were also supposed to be posted on the TDMS Site Council public-facing website. However, it appears that did not happen in these instances. In this case, the district failed the Site Council by not providing the council access to update the website themselves or post meeting notices to it. The material provided appears to show there was a technical violation of the public meetings law. Based on the information available in this preliminary review, there appears to be a substantial and objective basis to believe that the counselors violated public meetings law. The recommendation is to move this case to investigation. Should it move to investigation, we would most likely recommend a letter of education and training.
Thank you. Commissioners, any questions go ahead, Chair Fiscom.
Mr. Chair, I yield if there was somebody else, but I don't see a hand. Mr. Sullivan, welcome for your maiden voyage with us. We appreciate it. Do you have any information about how this complaint arrived at our office, given that it appears to be that the respondent and the complainant are from the same place, from the same organization? So I'm not trying to argue the conclusion here, but that looks to me like it's some kind of internal matter as opposed to external matter. Executive, Mr. Sullivan, either of you can answer if you have any more information.
I'll address it because Mr. Sullivan's been here 1 week and I'm very grateful he took over presenting. But in the preliminary review, the complainant is on the school board's board of directors. The site council is a separate governing body within the school district. The school board in this case, when the site council started a little less than a year ago, the school board approved an operating plan that told the site council, post notices of your meetings on Parent Square. The complainant, as I noted, is on that school board and voted to approve that. It is that directive to the site council that causes the problem because that doesn't satisfy public notice. The respondents might be better able to explain why the complainant chose this route, but
thank you.
Yeah.
Thank you, Chair.
Okay. Any other questions? Seeing none, we'll now turn to the respondents. And who's going to speak first, or who's going to speak for the body? We'll start with Miss Kelly. Miss Kelly, do you have?
Sure.
Would you? And by the way, you don't have to respond either. So go ahead if you'd
Sure.
like to speak, and now's your opportunity.
Thank you for the opportunity. I'm not necessarily speaking for the group, but can just share my perspective, which I'm sure you all read my very lengthy letter. And if you stuck with it to the end, I very much appreciate it. The complaint that you received is in fact from the vice chair of our school board of directors. So in the relationship that we play with the school district, her role would very much be like a leadership role, a mentoring role, a partnership and collaborative role, which is the description of how site councils operate. It's a collaboration between various bodies within the school district, and going through something like this sure doesn't feel very collaborative. Rather than if there was a perceived issue, just having a conversation, rather than going through a more formal process where something could have been mitigated, probably would have been much more appreciated and kept that relationship more collaborative. Part of the relationship and the collaboration required providing information to the district about our meetings, which actually followed the school board meeting calendar. And that's what was communicated in the fall and approved. And actually our operations plan is posted on the district website. So if you would consider that public notification, that it's on the district website, but maybe not in the exact specific place that Vice Chair Richardson wanted it. That it was there for the regular meetings already. But the specific complaint names me pretty directly in saying that I did things very intentionally to withhold information from the public. And I think in the response letter that I sent, I outlined some things that I did do very intentionally, which would have helped us get public notification aligned appropriately, including trying to draft some flyers to post at the school and in the district and around town, which I never received a response that was approved from the district office, and asking for meetings with the superintendent in the district office, which that email was never responded to. I sent something twice to them, and then reaching out to legal counsel to try and get some guidance also, which that communication was also not responded to. So while the complaint says that I did things very intentionally, the things that it's saying that I did intentionally was not done intentionally. I was not intentionally withholding information. I was actually really trying to do a good job and provide more notification than maybe some of the other site councils do in our district. Your question about how did this come to you, I'm not sure. I do think it would have been more meaningful to have an internal dialogue and discussion where it was potentially recognized that I was doing my end of the communicating by providing the district office with the information, but there has to be some accountability on their end too, to follow through with that information and get it where it needs to be posted.
Thank you. Yeah, it certainly seems to me that someone pressed the red button and escalated real quickly instead of holding hands and coming to the Ethics Commission and saying, help us comply. So
yeah.
For any of the other respondents, do you have anything to add to Ms. Kelly? If not, we might have some commissioners to ask some questions. Anybody want to add anything to Ms. Kelly? It appears not. So, okay, commissioners, any questions that you might have for the respondents?
Sure.
Commissioner Thompson.
Ms. Kelly, so if I understood you right, you provided notice of your meetings to the district office, and that's where it stopped. Is that correct?
So yes, I believe so in all of the ways. And so for the regular meetings, that information was provided in our operations plan, saying that we're following the district school board calendar for our meetings. That information was sent to the district office in the fall, which could have generated a meeting calendar for the rest of the year. In addition, the vice principal of the middle school, who was kind of my admin liaison during the month of February, the two meetings in question, it's because the principal was on leave of absence, and that's typically who I would have provided the information to, but I was actually on the phone with the vice principal as she was telling me, I want to submit this information to the district office to make sure that I'm getting things right and not doing anything wrong. And that was specifically for that February 8th meeting, which wouldn't have followed the district school board calendar. And that was provided in advance to the district office. So it does seem that there was a bit of a gap, which had the information been followed through with and actually posted and acted upon, that we wouldn't be having discussions today.
Thank you very much.
Yeah.
Thanks.
See, Ms. De Leon, go ahead.
Just to verify or just to specify, we don't have control as a site council of our district website for posting at all. So we had to go through channels to be able to get anything posted on it. We had to tell our building admin, and they had to, can you hear me?
Yes.
No.
Okay.
That's,
We can't hear.
Barely. Okay.
So we had to tell our building admin who would then in turn email or tell our district admin who is posting it onto our website. And then that would get to our director of communications to change that website for them. We had no control over it. So one of our ways of the original complaint is we created a working document for them to post a link of all the dates so that we could post any changes to it. And they posted that on our district website, so we had access to be able to update things very, very quickly. But our school board doesn't, or our school district admin does not like that way of communicating. They want to be able to control it. So,
Okay.
Give you guys that heads up.
Thank you. We were able to, just so you know, your speaker was a little bit difficult here in the room. We were able to hear most of it, but I'm not sure if the other commissioners were able to hear it. But all right. Well, that said, let's go ahead and consider this matter. I'll just signal that I'm inclined to get this ironed out. It looks like there's a technical violation. Looks like the commission desires to help them get compliant. And it seems like the process to have that happen is to move to investigation and then move to a letter of education. I would be inclined to support that, but now's the opportunity for the commissioners to make any motions that you might want to make or comments. Vice Chair Fiscum.
Mr. Chair, I appreciate the sense of your latest comment. What I was going to say was, this is an example of the kind of issue that comes to us, which creates for me unease. I'm uneasy with this because this appears to me to be a local issue that could have been, if not even my bias is, should have been resolved locally rather than elevating it here for our consideration. That's an option. There's nothing wrong with that option. It just it strikes me that this could have been resolved locally. Two approaches. One is to dismiss and assume that the parties have learned something, have been educated through this process. The other approach, which our staff has suggested, is the possibility of moving to an investigation with a letter of education to resolve the issue. And I'm comfortable either way. I would tend to be in favor of dismissal, assuming education has occurred. Colleagues?
Yeah, I see Commissioner Mason has his hand raised, and then we'll go to Commissioner Payne. Go ahead.
I would agree. Thank you, Chair. I would agree with Commissioner Fiscum. It seems like notice wasn't properly posted, whether that was, an inner situation or whatever. But I think if you move this to investigation, you create, more uncertainty or more potential adversarial activity amongst the board, which, in reality, I feel like that whole school district would be on, or the whole district would be put on notice for proper notification of meetings. And I think this whole exercise probably suited its purpose, and you don't need to move forward with an investigation. So I would support the motion to dismiss. If so, Vice Chair Fiscum so moves.
Okay, thank you, Commissioner Mason. Commissioner Payne.
Thank you. Sorry, trying to unmute there. I'm understanding from staff, and maybe somebody can explain this to me more clearly, that we have two separate public bodies here, but that what's happening in practice is that the respondents are relying on the district to post the notices and are not actually taking on their own responsibility of ensuring that the notices are being sent out to the public themselves. So I do understand that education here is important, but I think that there is a problem here where, because the district is being left with all of the responsibility, that we have a public body here that is not taking its own responsibility to ensure that these notices are going out to the public. And maybe I'm misunderstanding that, but it's a bit because I think we have its own public body, that they have their own responsibility to ensure that these notices reach the public. And if there is a problem here with the way these two public bodies work together, and we feel that if we dismiss that the education here has already happened, then I defer to my commissioners on that. But I'm understanding from what staff has said that the violation here is that this is a separate public body and that they have their own responsibilities here. So I'm actually inclined to move this forward, and because I think a letter of education may be important here to help these respondents take on their own responsibilities, follow the public meetings laws. And that's where I'm leaning on this, because I think they cannot just rely on the district to post their notices. But I may be misunderstanding that, and maybe staff could explain that better to me as to why the if I'm misunderstanding that.
Thank you. Thank you, Commissioner Payne. A couple administrative items real quick. Ms. Kelly, I see your hand is raised. We're not at the time right now to take any additional comment. We're discussing as commissioners, unless commissioners have a question for you, we might allow that, but we'll see. So that's number one. Number two is we have someone, a journalist who's attending to enter, and we just want to verify who that is. Are they on the line right now?
They are now, yes, with the Hepner Gazette.
Okay, the person with the Hepner Gazette, could you please identify yourself? Hello? Whoever's with the Hepner Gazette, will you please identify yourself? Let's go ahead and remove them then. And then I saw that Mr. Johnson came on and see that. Okay, he's back in the waiting room. Okay. I think that actually Commissioner Payne's persuasive to me. I'm just going to make my comment. I like both options, but I do agree that that this separate body needs to stand on their own feet. We're here. It's been escalated. I don't think it should have been escalated. I agree with you 100% on that. I think candidly it was a dumb move. People should just come and be adults and come and get help. But we're here. And I do think that these folks need to stand on their own regardless and not be dependent on the school district. And so for that reason, I would support a motion to proceed. But I won't be making that motion, and I leave that opportunity to other commissioners. If anybody's prepared to make a motion, you're welcome to make a motion at this time.
Mr. Chair, I'll make a motion to proceed with an investigation for the purpose of
Commissioner Burke. Actually, everybody's frozen. Yeah.
They're all frozen on my end too.
Give
Hello?
us a second. Okay, Commissioner Burke, can you hear us?
Yes, I can. I'm sorry. I don't know what happened there, but I
No,
guess
everybody froze. Everybody froze. So
Okay.
go ahead. You are about ready to make your motion.
Yes, for the purpose of going through this process, advancing our mission, and which is education, and potentially generating a letter of education, I move to proceed with an investigation on this point.
Thank you. Any commissioners have any comment on the motion? Are there any other motions that any commissioner would like to make? Seeing none, we'll call for the vote. Oh, hold on. Go ahead, Commissioner Mason.
Oh, I was just going to say, wasn't that out of order? There's a motion on the table.
Okay. All right. That said, we'll go ahead and we'll call for the vote.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Commissioner Newell,
Aye.
Commissioner Fiscum,
No.
Commissioner Payne,
Aye.
Commissioner Mason,
Nay.
Commissioner McCauley,
Nay.
Chair Lindsay.
No.
Motion failed 3-5.
All right. If I remember right, do we need to have a motion, an alternative motion, or we're just done? Our legal counsel shaking his head saying we're done.
Yeah, I mean, you could go ahead.
You need 5 votes to move something forward. The motion was,
We don't have that. Okay.
Yeah.
Okay. Respondents, thank you for being with us today. We have failed to move forward with investigation, which means by default, the matter's been dismissed. I do highly recommend that you please work with the Government Commission staff from here on out and make sure that that you're not dependent on anybody to help you comply, but that you're on your own to comply. So thank you for being with us today.
That was just one.
That was just one. Sorry. Sorry.
oh yeah, you have to do for all.
Sorry.
Yeah.
It's a Friday. Please be patient with me. Thank you. That was
Item 80.
actually it was that agenda. That was agenda item 87. Commissioner Fiscum.
Mr. Chair, I'd be happy to make a motion if I have the question first, which is, do you want the same motion that was made on item 87?
Yes.
Okay, I will hereby move that. I forgot what the motion was. Oh,
Or that we proceed.
Burke made the motion.
No.
So you can also make a motion to be dismissed. We're fine with that.
Okay, well, that said, Mr. Chair, thank you for that freedom. I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Ms. Katie Kelly, pardon me, Ms. Audrey Moore, pardon me for mispronouncing that, has violated provisions in ORS 192.640, executive session law, and that this complaint be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Nay.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Nay.
Chair Lindsay.
Aye.
Motion passed 5-3.
Vice Chair Fiscum, agenda item 90.
Mr. Chair.
89.
With regard to agenda item 89, I move the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Kirsten Benko has violated provisions in government ethics law and that this complaint be dismissed.
Just to clarify the motion, because this isn't government ethics, this is public meetings.
Public meetings law, I appreciate the clarification. My motion should say has not violated public meetings law and this complaint be dismissed. Council, thank you.
Thank you, Vice Chair Fiscum. Seeing no comments, we'll call for the vote.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Nay.
Commissioner Thompson,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-0, or 3, sorry.
Vice Chair Fiscum, agenda item 90.
No, 90 is separate.
That's
skipped
right. That's 90. Sorry. Yes. So 91. Thank you.
Mr. Chair, with regard to item number 91, I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Priscilla Irving has violated provisions in the public meetings law and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Nay.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Chair Lindsay.
Aye.
Motion passed 5-3.
Thank you. Vice Chair Fiscum.
Mr. Chair, on item number 92, I hereby move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Kelly De Leon has violated provisions in the public meetings law or warrant for the review and that this complaint be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Nay.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Chair Lindsay.
Aye.
Motion passed 5-3.
Mr. Fiscum.
Mr. Chair, item 93, I hereby move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mindy Clausen has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Nay.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Chair Lindsay.
Aye.
Motion passed 5-3.
Thank you. Yes.
I would like the commission to consider, before we let these people leave, consider rescinding its vote on 87, the first one, because that dismissal would have been different from the rest. So rescinding its vote and then revoting on the same vote
All right.
for Ms. Kelly.
To rescind, do we make a motion to rescind and vote and then vote again, or we can just re-vote and it supersedes it? Okay. Yeah, we'll just have, so it's agenda item 87.
Mr. Chair, I hereby move the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Katie Kelly has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. We'll call for the vote.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Nay.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-3.
Okay, thank you. Now it's official. Thank you for being with us today, and we'll invite you to have a good weekend. Thank you.
Thank you.
Okay, commissioners, we're now moving to agenda items 90 and 94. And that same topic.
Actually, so Josh, who took over from me, both of us can explain this. When I drafted the preliminary reviews, when we get the complaint, we send the information. We reached out to the district to get contact information. And the district, apparently, Mr. Russell, Josh can explain, Mr. Spino had resigned and wasn't on the site council at the time of these events. He never received our notices. No one communicated with him. Didn't even know this was going on. And then Mr. LaDucera had been the middle school principal. He was on administrative leave. Again, we reached out to him through the district. They did not convey the information. We got nothing back saying he wasn't participating in the site council because he was on leave. So while the reports in your meeting books recommended the same with their cases as the others, given the additional information Josh has discovered, we would like to, the commission could consider simply dismissing, because had we known that at the time, we wouldn't have brought the cases again.
Thank you. And those would be two separate motions.
Yeah.
Okay, Vice Chair Fiscum,
Mr.
agenda item
Chair,
90.
with regard to item number 90 on our executive session agenda, I hereby move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Ryan Delacour, if I'm saying that name right, has violated provisions in the public meetings law or warrant for review, and that this complaint be dismissed.
Seeing no comments from commissioners, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully, Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Vice Chair Fiscum,
And
94.
Mr. Chair, and member 94, I hereby move that the commission find that the complaint information available during the preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Russell Spino has violated provisions in the public meetings law or warrant for review and may be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner McCauley. Aye. Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Okay, thank you. We'll now go on to agenda item 95 regarding Tara Bryson. And is she in the meeting?
She will not be appearing.
She will not be appearing exactly as it says on my piece of paper there. Why didn't I just look to the left? Okay, thank you. For the commissioner's knowledge, Willamette Week has joined us as well. Mr. Jacquis from the Willamette Week has also joined us at the media. All right, agenda item number 95, Investigator McIntyre, go ahead.
All right, thank you, Chair Lindsay and Commission. This is Andrew McIntyre for the record. Agenda item number 95 is a preliminary review for Tara Bryson, regulatory specialist with the Oregon Liquor and Cannabis Commission, also known as the OLCC. The complaint in this matter alleged that Ms. Bryson may have violated Oregon government ethics laws by using her official position as an OLCC agent to solicit donations from bars located within her jurisdiction in order to bolster her husband's campaign funds. Her husband was running for Klamath County Sheriff at the time. The commission staff contacted the complainant for more details and information, and the complainant was unable to provide any sort of specifics. They stated the basis for their complaint was they heard a rumor, and then they went on a website and it listed donations to Mr. Bryson's campaign, and those donations included bar owners. So that was the basis for the complaint. The information available at this time indicates that the bar owner, who did in fact contribute to Mr. Bryson's campaign, the reasons for his donations had nothing to do with Tara Bryson's position with OLCC, had a relationship or he knew of Mr. Bryson prior to that. Further, it should be noted that the Elections Division of the Secretary of State's office regulates campaign finance and campaign activities. Therefore, even if Ms. Bryson had solicited donations for her husband's campaign, which I want to make it very clear, it does not appear that she did that. That would fall outside the commission's jurisdiction anyways. Therefore, based on the information available in this review, there does not appear to be a substantial objective basis to believe that Ms. Bryson violated Oregon government ethics laws, and the case should be dismissed, and that's the recommendation.
Thank you, Investigator McIntyre. Two questions. Is it the same sheriff, Mr. Bryson, that was here last time?
That was a different sheriff. I believe that was Sheriff Cabler.
Okay.
This was an individual who was,
That's right.
was campaigning. Mr. Bryson was campaigning for sheriff.
Right, right. And then did you actually speak with that bar owner?
I did.
Just a telephone call or
A telephone conversation, yes.
was that, was the purpose of that just to kind of independently verify some statements?
Correct. I mean, just to make sure and ask him, what was his motivation and reasoning for donating, whether or not she used her position or leveraged that in any sort of way to gather donations. And he was very adamant that didn't happen. She's always been, he indicated that Ms. Bryson's always been fair and professional.
Got it. Thank you. Commissioners, any other questions for Investigator McIntyre? Seeing none, do we have Commissioner prepared to make a motion? Vice Chair Fiscum, maybe?
Mr. Chair, item 95 on our agenda, executive session agenda, I hereby move that the commission find that the complaint information during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Ms. Tara Bryson violated government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. Commissioners, any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Burke,
Sorry, fumbling with the mute there. Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Okay, commissioners, we are now moving to agenda item 96 regarding Governor Kotek. Attending for her today is her attorney.
He's entering the room now. And
Oh,
Chair, Mike Rogaway with the OPP, Oregonian, excuse me, is also joining.
okay. Commissioners, if you didn't hear that, OPP has joined as well.
Oregonian, yeah.
Oregonian has joined us as well. Mr. Johnson, welcome. Thank you for being with us today. My name is Sean Lindsay. I'm chair of the Oregon Government Ethics Commission. Now is the opportunity to hear the matter with your client as the respondent, Governor Kotek. And the way that this will proceed is we'll have our executive director report on the preliminary review. After that, commissioners may have some questions of the executive director. Then you will have an opportunity as well to speak on behalf of your client, and we may have some questions of you as well. After that, then the commission will deliberate and consider whether to move forward with an investigation or not. Obviously, we're not finding any violation here during this meeting. It's just whether or not to proceed with an investigation or not. That's the process today. So with that said, Executive Director Myers, please go ahead.
Thank you, Chair Lindsay, Commissioners. Susan Myers for the record. So item 96 is the preliminary review report for the case involving Governor Kotek. He is represented in this matter by Attorney Derek Johnson. The commission originally received 2 complaints on March 25th. This followed a media reporting at the time. And so we opened this preliminary review case. We subsequently received numerous additional complaints, all of which, like the original 2 complaints, simply referenced the published news articles and suggested that Governor Kotek was violating the ethics statutes by allowing her spouse, Amy Kotek Wilson, to work in the governor's office and by providing her with staff and other resources to do so. As the commission knows, the ethics statutes in Chapter 244 focus on personal financial benefits, conflicts of interest, making a decision that or taking action that would provide a financial benefit or detriment to yourself, your relatives, or your businesses, use of office, using your position to obtain financial gain or avoidance of financial benefit. The nepotism statutes likewise are about personal financial benefits, taking employment actions that provide your relative or household member with a financial benefit. So the report that is in your meeting books, as the report in your meeting books indicates, the information in this case does not appear to establish a substantial objective basis to believe that Governor Kotek violated the conflict of interest, prohibited use of office, or nepotism statutes, because the available information does not indicate there was any financial benefit being provided to the governor's spouse. In terms of conflicts of interest and use of office, as I said, it focuses on financial impact. The first partner does qualify as the governor's relative. Thus, the governor would have a conflict of interest or be engaged in a prohibited use of office if she were to take actions to provide her spouse with that financial benefit. In this case, the information indicates that Amy Kotek Wilson works as an unpaid volunteer in the governor's office. Further, there is no information to indicate that she has used that position for personal financial gain, such as by engaging in private employment or private business using the governor's office resources or contacts. In the absence of any evidence of a personal financial impact on the governor or on Amy Kotek Wilson, there would not appear to be a substantial objective basis to believe that she violated ORS 244.040 or 244.120. In terms of the two nepotism statutes, ORS 244.177 prohibits public officials from taking employment actions, hiring, firing, promoting, etc., for a relative or household member. 244.179 similarly prohibits public officials from directly supervising relatives or household members. Both of these statutes, however, have specific statutory exceptions permitting a public official to appoint or directly supervise a relative or household member in a position as an unpaid volunteer for that public official's agency. These exceptions, these statutory exceptions, would appear to apply in this case and allow Governor Kotek to appoint her spouse to a position as an unpaid volunteer in the governor's office. During this preliminary review, we reviewed the various media reports as well as emails that were released from some former officials in the governor's office. From those emails, it is clear that some of these staff members may have had concerns about the circumstances surrounding Ms. Kotek Wilson's position. These concerns, however, appear to be based more on political perceptions and staff members' misunderstanding of the Oregon government ethics laws. For example, there were concerns raised about the governor asking an advisor to contact Cascadia Behavioral Health on behalf of a former colleague of Ms. Kotek Wilson. Such a request could be perceived as inappropriate, absolutely, but that does not mean it would violate the ethics law because the former colleague is not a relative or household member. Another email questioned why Ms. Kotek Wilson had not completed the conflict of interest disclosure form that was being completed by other employees. This and all of those emails appears to suggest that some of those staff members may not understand what constitutes a statutory conflict of interest or how such conflict of interest must be disclosed. As described, those conflict of interest disclosure forms are not required by the Ethics Commission and would not satisfy the conflict of interest disclosure requirements in the statutes. In this preliminary review, we did not identify any information to indicate that Amy Kotek Wilson was a paid employee of the governor's office or that she was using her position there for personal financial gain. Thus, there does not appear to be a substantial objective basis to believe that Governor Kotek may have violated ORS 244.040, 244.120, 244.177, or 244.179. Recommendation is to dismiss this case.
Thank you very much, Executive Director Myers. Commissioners, now's the opportunity to ask any questions that you might have, that we might have of Executive Director Myers. Vice Chair Fiscum, and then I've got 3 hands raised. We'll start with Vice Chair Fiscum.
Thank you, Mr. Chair, and I will, this is a quick question. I think I already know the answer, but I will, for the record, ask it. I appreciate your comment, Director, about having reviewed the some social media transcripts, especially in relation to the 3 governor's office staff persons the media has said have left the office. My question is, did you talk to those individuals as part of this review?
I did not. Had I seen information in those social media or email posts to indicate that they had anything to say that related to potential violations, anything about money or financial interests, I would have, but it did not appear from what I saw that what they were talking about or concerned about related at all to what our statutes require.
Thank you, Chair.
Thank you. Commissioner Burke, go ahead.
Thank you very much. That was my immediate question as to whether or not you had actually interviewed those persons. You've made a decision, if I understand you correctly, through reading the email chains that they were involved with. But, you know, I know, and I think all of us know from having been involved in politics, that when you are writing anything, especially something that could be in the public record, you're going to be very careful about how you word things. You're not going to want to burn bridges necessarily. I mean, there are a lot of issues that are involved with writing an email. So I'm actually a little bit surprised that you didn't go through the additional step of interviewing those people. It may well be that it is exactly as you say. It may well be that they were hedging based on what they were putting in the written record. But I'm curious as to why you didn't interview them, given those dynamics.
I appreciate the question. And should the commission move this matter to investigation, I would be happy to interview those people. In the end, what I was considering was the governor, Ms. Kodak Wilson, is in an unpaid position. The only questions under our statutes are not the concerns raised by these people, but do we have any information to indicate that she is paid? She's not, so the nepotism statutes are satisfied. It falls under the exception. Do we have any information to indicate that she was engaging in private business, writing a book, doing anything that would have a personal financial benefit to her or impact on her? And based on the information I had in front of me, that does not appear to be the case. But I appreciate that the commission may want me to interview the 3 former employees.
You're on mute. Commissioner Burke, you're on mute.
I was going to ask if I could follow up really quickly.
Go ahead.
Okay. You know, there are other issues here. You know, there's the use of office, whether or not the office was appropriately used, as is suggested, you know, by the attorney who provided us with the response, other materials. And I think that, you know, the state is watching us. Everybody is watching us very carefully. And after, you know, the John Kitzhaber, Sylvia Hayes situation, I think it is very important that we be diligent in making sure that what is asserted in your report is actually correct, that the resources provided to the first spouse, if I'm using that term correctly, you know, were appropriate, and the usage of those resources were appropriate. And we should determine that, I think, on more than just the word of the attorney responding in this case.
Thank you, Commissioner Burke. Commissioner Mason, you have your hand raised.
Yeah, thank you. You know, one of my questions is, I know that the current executive director, Ms. Myers, and the previous director, I think, met with the governor-elect staff in either late 2022, because this was part of one of our meeting books. And they, you know, I don't believe the governor-elect staff or the governor-elect herself was in that meeting, but it would be interesting to know if any of those staff members that resigned were part of that. So I guess, Director Myers, do you have a record of that? Do you remember who was in part of that meeting?
We met, former director person and I met with the governor's office general counsel and deputy general counsel. I do not believe that any of the 3, I don't believe Ms. Tibbs had been hired or appointed yet. It is possible that Ms. Cooper may have been present. I don't recall.
But I think that is something that would come out in the investigative process, because I think it's an interpretation of what ethics laws are from those staff members that that resigned. Because frankly, I mean, the only reason there's a complaint in front of us is 3 people resigned and that made the news. That's the only reason citizens sent in a complaint. And so, I definitely agree with Commissioner Burke. I mean, we definitely want to be thorough. And if we haven't talked to the people or interviewed those people that really drove the complaint to even occur, I think it would be viewed as unthorough. I think the credibility of the commission would be questioned. People would probably wonder how thorough you can be in a 60-day preliminary review. And so I think for the greater public good, obviously, I think that's important. But I really think that we should know, frankly, I'm curious to know, what governor's staff has been through ethics training, or what, the governor, I know was in the legislature for 10 years. Do you keep records of what kind of training, some of these folks go through? Do you have a record of that? And I think that some of those items should be fleshed out in an investigative process. Thank you.
Thank you, Commissioner Mason. Commissioners, any other comments of Executive Director Myers? Seeing none, Mr. Johnson, thank you for being with us today. Now's your opportunity to respond. Thank you.
Thank you, Mr. Chair. Thank you, commissioners. Thank you, Executive Director Myers. And thank you also to the tech folks who are making all this work so well. I appreciate that, having been bumped out of the room twice. I apologize for jumping in, and I appreciate being here right now. I share the same concerns that the commissioners do about the Oregon Government Ethics Commission being viewed as a political tool, or being used as a political tool. Its role in holding public officials accountable is important, but it's just as important to dismiss meritless or claims that are based on no evidence. And that's what you have here, as the executive director's very thorough and complete report sets forth. There is no evidence of a violation of the Oregon Government Ethics Statutes. That's what is before you. Now, Mr. Commissioner Burke, I appreciate that you're concerned about what is appropriate and what is not appropriate in the governor's office is something that we should all be concerned about. However, what is appropriate is different than what is legal or allowed under the ethics statutes. Appropriateness falls under what we would consider a political concern, and the political concerns are not the purview of the Oregon Government Ethics Commission. I know a little bit about that, having served on the commission about 1 million years ago. And so with that, I'd also like to say thank you for your service. Now, the keys to these complaints were the governor's spouse, who is by statute a public official. So the governor didn't appoint her or make her a public official. She is a public official by statute. So that is the first step that exonerates the governor from any wrongdoing. She didn't appoint a family member to a position of public officialdom. The second is she is working strictly as a volunteer. And if she is working as a volunteer, there is no personal financial gain, and she is exempt from the anti-nepotism statutes. Now, there was no significant mention of an additional piece of investigation that the executive director made, and that was a series of questions that she posed to both the governor and to the first lady. And so, just to go through those, to make clear, the governor and the first lady did respond to questions about her financial situation, whether she was working at the time, whether she was getting financial benefit, anything like that. And I'll just run through those real quickly. to confirm what the executive director found and what she reported in her report and her recommendation to dismiss. And that is, she became a volunteer public official when the first spouse, when her wife was sworn in. The purpose of her goal was to work as a volunteer to serve the people of Oregon and to use her professional expertise. She was employed prior to taking office as a governor, but that was ended in July of 2021. Her most recent appointment had been with Cascadia Healthcare in Portland. She became a public official in January of 2023. Since January 2023, she has not been employed at all. The question was, have you been employed at all? If so, please explain. The answer is one word, no. She's also not engaged in any self-employment activities. That was an additional question. The answer is no. She's not working on a contract. She's not working as a consultant. The analogy between Governor Kotek and the First Lady is not to make an analogy between them and the situation with Governor Kitzhaber and the first partner, Sylvia Hayes, is not appropriate, and it's not inapt. It's inapt. Sylvia Hayes was working as a consultant while she was the first partner. The first spouse, Amy Kotek Wilson, was doing no such thing. In regards to her office space, she said that she works in the office about once a week, and she has never used her office or the state provided equipment for any purpose other than those associated with her volunteer duties. In addition, there are other instances where volunteers work in the governor's office. There's one instance of a volunteer intern who worked in the governor's office, had access to office space, and was also provided with a phone and a laptop to do the volunteer work that they were doing. There's another volunteer who's coming to work in the governor's office later on this year, going to be working there and have access to office space, and will be assigned a phone and laptop. So this is not something that is out of the ordinary. Regarding Cascadia Behavioral Sciences, this was a person that was a colleague. She was not a relative or a household member of the governor. That being the case, that's not something that falls within the purview of the Government Ethics Commission. Again, I want to reiterate that it's important that the commission take these things seriously, and I understand that, and I think that they have. The executive director's report, frankly, was more thorough than the defense that I provided on behalf of the governor. She went the extra mile to ask questions of the First Lady and the governor and got those answers. And based on that, there's no evidence in the record. There's no evidence in the emails that have been provided to the public. And there's no evidence in the responses that the governor and the First Lady provided to indicate any substantial basis for a violation. And so we ask that this complaint be dismissed. Thank you.
Mr. Johnson, thank you very much. And also thank you for your service on the commission previously as well. That means a lot to us. Commissioners, now's the opportunity to ask Mr. Johnson some questions. I see a couple hands raised. We'll start with Commissioner Burke. You're on mute, Commissioner Burke.
Oh, I hate this mute button.
So do I, so I'm going to keep mine on.
In any case, Mr. Johnson, I want to thank you for testifying today. I'm happy to know that you were once a commissioner. It's a small group, and I thank you for your service as well. I would also like to thank you for a point of clarity. You pointed out that in my earlier speech, or my question to Commissioner Myers, that I used the term appropriate, and whether or not something is appropriate or not is you are correct, not something for which our commission should be concerned with. And I think the reason why I use that word is because I'm not an attorney and perhaps not as precise in my speech as you are. But when I use that phrase, I was actually meaning to use the word legally in the context of what we are authorized to govern. I also want to make it very clear that I'm not out to get the governor. If an investigation shows that everything you say is correct and that no law was violated, I would happily move to dismiss. Nobody wants to see a high official in this situation, and I know this is going to be viewed as partisan. For what it's worth, I'm not a Republican or a Democrat. I just want to see good governance, as I'm sure that you do, and as I'm sure that all the other commissioners do. We can't get this wrong, and there are issues and I guess I want you to respond to this. There are issues that, use of the office, use of the resources, use of protection, all of those things may have been done within the scope of the law. But it's not certain. And what do we have? We have your letter, which is very well written and persuasive. We also have testimony of the governor and the first spouse. And, I think that while they may certainly be telling the truth, I don't think we should necessarily take that at face value in a case like that. And I do think that it is important that we interview the three people who resigned. This may be a situation where, I wouldn't say there's no evidence. I would say there's not compelling evidence. However, that's what the point of an investigation is. And I think that an investigation in this case would give us enough information to proceed forward or dismiss with confidence. I think it would be good for the governor, as if this was ultimately dismissed, it would remove all doubts that she had done anything wrong. And I think it would also advance the mission of our commission, which is to educate, and perhaps we'll be educating ourselves. But anyway, I wanted to respond to that comment you made about the word appropriate and clarify my position a little bit and ask you to respond to that.
Sure. Thank you, Commissioner Burke. And I did not
sorry to interrupt, Mr. Johnson. Sorry to interrupt. I'm unclear what the question is.
Well, thank you. The question is how do you respond to what I said with regard to, after I clarified it, subsequent to Mr. Johnson's comment of my earlier comment. Sorry if that's a verbal pretzel, but that was what I was asking him to respond to.
Thank
you. Well, thank you, Commissioner Burke. First, I did not in any way intend to suggest that there was going to be some sort of partisan approach by the commission in evaluating this set of complaints. What I will go back to, though, is that the standard that the commission is supposed to apply in the preliminary review phase is whether there is, and I quote, substantial objective basis for believing that an offense or violation may have been committed. There is no evidence of a basis to believe that an offense or violation is committed. There have been reports in the media of use of an office in the governor's office, of the first lady working as a volunteer, of the protective service providing protection. All of those were analyzed and evaluated and investigated by the executive director, and she found no substantial basis. So to take the next step is contrary to the guidelines and the requirements of the statute. That's what my response would be. If there are other questions, I'd be happy to answer.
Thank you. Commissioner Mason.
Thank you, Mr. Johnson. Great to have a former veteran of the commission in front of us, which also you probably would have the best explanation then to why an ethics opinion was asked of the Oregon Government Ethics Commission by the governor after a complaint was filed. Or can you answer that?
Actually, I was not involved in that decision, but I would say that what the governor's trying to do is get it right, and she asked for clarification. There was a lot of publicity going on at the time, and so she asked for clarification from the Ethics Commission so that she could get it right. And subsequently, she actually had a press conference where she said that she's going to sort of back up and wait until she can find out what's the right step to take in deploying the first spouse, and not develop a office of the first spouse as she was thinking that she might want to do prior to the media reports. So in all of my dealings with her, and I think the dealings that she's had with the Government Ethics Commission, she's tried to be transparent and try to understand how the ethics laws apply to a first spouse, and how they should apply, and how she should go about using the first spouse's expertise and experiences in a way that helps the state of Oregon and is consistent with the strictures of the government ethics statutes. And so far, she has done that. There's no substantial objective evidence to suggest anything otherwise.
Well, Mr. Johnson, I guess I would just ask if she became if she became a public official, basically the swearing in, the day the governor took office. I'm just curious why it took 14 months to either ask for an opinion or for all of the subsequent events that led to the multiple resignations of staff members. So I think that's just there's some questions that I would hope would get flushed out in the investigative process.
You have a question, Mr. Mason? Commissioner Mason, is that a question or?
Yeah, that's a question for Mr. Johnson. I mean, if he can elaborate on it, why an opinion was asked, 14 months into, it looks like from the time that the governor's spouse became the public official.
Well, first, let me. I'm not in the governor's head on the timing of those things, but what I can say is that's not really, again, an issue that is within the Oregon Government Ethics Statutes 244. That's again more of a political public image concern, and people can talk about that and can raise that and can address it in the media or at the ballot box. But again, that's not what the Government Ethics Commission is supposed to be addressing when she asked for an opinion or when she didn't. What they're supposed to be addressing is whether there's evidence of a violation. Again, the executive director has done her investigation, and there's no substantial objective basis in the record. And again, that leads to a dismissal.
Thank you, Mr. Johnson.
Thank you. Commissioners, anybody else have any questions of Mr. Johnson? Okay, seeing none, I think it's time to make a decision now. I'm going to go ahead and share what I'm thinking, and let you all commissioners get ready to make a motion or not. First of all, I agree 100% with Mr. Johnson that this commission should not be used as a political tool. Everybody knows how loath I am of having people exercise political retaliation through this office, and this body should not be used for that. I also very much appreciate the governor's cooperation. I think she's been very cooperative, and I appreciate that. I also think that this body should not be used to go on, although we need to be thorough, we should not go on unfounded fishing expeditions either. And I very much appreciate the statement that what we need to consider here is whether there's a substantial objective basis to move forward with an investigation. And where I'm at on this is the words available information. And thus far, it's been the newspaper reports, it's been the emails, and it's been the social media posts with very material allegations. And what comes to mind is in an earlier matter here, we asked investigator McIntyre how he had arrived at his recommendation. And one of the things he did was he visited with a third party to independently verify the statements that a respondent had provided. And that is the gaping hole that I see here, is that we only have the available information, which is material, and we have not independently verified some of these facts or investigated those facts. And thus, because of that, I do think that there is a substantial objective basis based on those reports to proceed forward with an investigation. I don't think that we should treat people differently. I've lost count, candidly, of the times that we've had respondents here at our office in tears, and we've told them, we're going to proceed forward with the investigation to independently verify some facts. And more than likely, it will be dismissed later. You'll be vindicated, but we need to iron out these facts to do our job. And so that's my position here, is not be used as a tool, but to be thorough. I do think that we've arrived at that line of a substantial objective basis. And I think the gaping hole here is to visit at least with those three individuals and whoever else they might lead to, and then do our thorough conclusion at that point. So that's my thought, and I would be supportive of a motion to investigate. But that said, it looks like Commissioner Payne has her hand raised. Go ahead, Commissioner Payne.
Thank you, Chair. I guess I really appreciate what you just said. However, I think where I differ is that the allegations raised here, even if substantiated, for me, still would not lead to a violation. There have been, as I understand, no allegations that the first spouse has an outside job, that the first spouse has an outside contract that would be used in some sort of financial way. So to me, interviewing those witnesses are not going to substantiate some sort of allegation that is going to change this landscape. To me, the allegations are not such that it would change anything in the report that we have before us. Those are the sort of facts that for me would change something. Right now, what we have is we have a volunteer, we have an unpaid spouse, and I don't believe that there are any allegations otherwise such that it would change anything before us. And we need to go talk to these people to confirm these allegations. The allegations, I think, were simply that a spouse was using the position in getting support from the police, and that she was using a government office. Well, the fact is what we know is that that's not a violation of the Oregon ethics laws, because she's a public official by nature and she's an unpaid volunteer. I just literally, I don't see, I guess, what anything is going to change at this point by confirming any allegations, because there is no violation of the ethics laws, as we know by Executive Meyer's report. So I'm leaning towards dismissing. I would support a motion to dismiss. I don't understand what
confirming the allegations at this point is going to do, because I understand that there are no allegations that the first spouse has any outside employment or any outside contracts. This is a very different situation than the situations that have come before us, and I just don't see what is going to change at this point.
Thank you, Commissioner Payne. Any other comments from commissioners? Vice Chair Fiscum.
Mr. Chair, thank you. And I want to first yield to any of my colleagues who haven't had a chance to speak yet. So thank you to those who have. I'll just say a couple things. The decision today for me is a very difficult one, not unlike others that we faced over the years. I want to make 2 points. First, on one hand, those who have talked to us, as well as my own view, is we need to keep two issues separate in our minds, if not our hearts. On one hand, politics. It's not our job. It's not our authority to engage in political issues of any kind whatsoever, whatever we might happen to as individuals. Think about those. What is before us is ethics laws on the books in Oregon. Nothing goes beyond that. We are not supposed to opine on how government is organized, how this governor's office is organized, how this governor's office is staffed, how it sets policy, who signs what when they arrive at that office and who doesn't sign what when they arrive at the office. All of those things are not within our purview. Our purview is the ethics laws. One of the issues I think that exists for us sometimes is that I think the definitions of the word ethics or ethical conduct are in the mind sometimes of the beholder or the user. For us, the definition is what are the laws on the books which the statute gives us authority to enforce or educate about with regard to Oregonians and especially public officials. And I think that there's a lot of misunderstanding on the part of a lot of folks about what our role really is and what our role really is not. Second comment is if we're inclined to move to an investigation, which ought to be considered by us and those who hear us a neutral act in the sense that it is an act not designed to establish that there has been an investigation. It is an act to decide that we think we need more information to make then that final decision at the end of the investigation, which can take 6 months. If we were to move in that direction, which is an if, because we don't know yet, it seems to me it would be incumbent on us as commissioners to specify what it was we wanted our staff to look at in the next weeks and months if we move in that direction. I thought of 3 things. I have mixed emotions about all of them. The first is to actually interview those 3 individuals who left the governor's office. I'm persuaded in part by my colleague, Commissioner Payne's notion that they probably aren't going to tell us anything that would constitute any actual violation of Oregon ethics laws, which is our purview, but we don't know that. We haven't talked to them. Second thing is we could assess whether the first spouse, since she became that public official some months ago upon the governor's inauguration, that she complied with all of the ethics laws appropriate for public officials. Us as public officials, she is a public official. Third thing that crossed my mind as I read the good report from our executive director was on pages 471, 482, and 483. There is the use of the word appears. The risk of what I'm going to say next is I start to wordsmith an investigator's report, which is not necessarily my job, but my question is there anything else that should be done to bring more precision to the use of the word appears? I understand that appears can have multiple definitions as well. So if we move in that direction, those are aspects of what we could ask our staff to look at. The bottom line, I basically am persuaded that this is something worth dismissing because I haven't seen any actual violation of yet, based on the director's report, that is within our purview. Would it be bad to move to investigation? No. And again, investigation often is a final vindication of someone's behavior as being, pardon me for the use of this word, Mr. Johnson, appropriate. Let me just say legal. That would be another way to verify that fact I'll stop. Thank you for your consideration, and I'm a little on the fence.
Thank you, commissioners. Commissioner McCauley.
Oh, I was just going to say, I really appreciate all the commissioners' comments. I'm really back and forth on this. I would say that I'm leaning of the same opinion as Commissioner Payne. You asked one of my questions in my head is what would we have staff look at as we move forward in this investigation? I think you bring up really good points. I would like Director Myers to comment on that if she wouldn't mind. But again, I'm the exact opinion of you. I think moving forward with it isn't a bad thing either. So I would like to know what we would look at if we move forward.
So addressing Commissioner Fiscum's 3 points. The first, as several of you have noted, would be to interview those 3 people. As Commissioner Payne pointed out, they may provide further detail or clarification as to what was in those social media posts and emails. But having them talk about, for example, the dignitary patrol unit being available, even if the dignitary patrol unit was made available, that's not a violation of the ethics statutes. That's permitted under the OSP policies. But yeah, I could ask those 3 people, I could interview them and ask them to confirm or provide clarification as to what was in their posts. Based on the material I've seen so far, even if everything in their posts was in fact true and valid, it would not appear to violate the ethics statutes. That's the reasoning in my report and the reasoning why I did not pursue that avenue in the preliminary review. Your second point was, since becoming a public official, has Ms. Kotek Wilson satisfied all of her ethical obligations? The immediate obligation she has as a public official is to file a statement of economic interest. She has done that. The other appears perhaps to be more of a fishing expedition because we have not had any allegation that she has done something. All public officials are expected to follow the ethics laws. And then the third point was the use of the word appears. In at least 2 of those instances that you noted, I wrote the report. We tend to, in a preliminary review report, insert that, especially in the analysis section, because our report is merely a recommendation. It is not a final determination. And it's more of, this is what it looks like to us, but it is up to the members of the commission.
Any other questions?
Thank you.
Commissioner Thompson.
Thank you, Mr. Chair. I, along with Commissioner McCauley, have been back and forth on this a couple of times. I do think that based on the fact that we can't get around the fact of the that we're talking about the governor. It is. We're not talking about the chair of a soil and water conservation district in Morrow County. We're talking about the governor. I do think and what's tilting me is I do think we owe it to the citizens of Oregon to absolutely look at everything and make sure that we are as thorough as possible. Like I said, Executive Director Myers' comment about appears, it would be great if we could clear those up and make sure that all the I's are dotted and the T's are crossed. So while I'm on the fence, I'm leaning toward making sure that we as a commission do everything we can to make sure that all the questions are answered, both for the sake of the commission and, quite frankly, for the sake of the governor. So this doesn't, if we move toward dismissal, finally, that we can say confidently for both us and her that we looked at everything, and you're right, there's nothing here. So I'm leaning toward proceeding to investigation, just so we can make sure we clear up absolutely everything.
Thank you. I think we've heard from all commissioners except for Commissioner Newell. Do you have anything to say or not? You're welcome to or not.
Thank you, Chair. I'm just, I'm working through those 3 areas where we would be requesting additional information if we move forward. I have no qualms with the use of the peers. I think that's appropriate in these sort of preliminary reports. So that's not of a concern for me. I don't think that there's anything there that needs to be tacked down. As far as the first spouse's ethical obligations, we learned that she has filed, and it does seem like we would be working outside of the bounds of what was sent to us if we were to start finding out whether she complied with everything there. As to the interviews of the additional, the 3 folks and additional interviews of them, again, what I heard from Commissioner Payne and from Executive Director Myers is that even if they confirmed everything in the allegation, it still wouldn't be a violation. And so are we being efficient with our time? Are we being efficient with our use here? Is this worthwhile to do just to make sure we've looked under every rock and every nook and cranny? I don't think it is. It feels punitive if we continue because there is no substantial objective basis at this point. I understand that people may disagree, but for me, that's where I'm leaning.
Thank you. Okay, commissioners, let's make a decision here. Are any commissioners prepared to make a motion at this moment?
Mr. Chair, in the absence of anyone else willing to do so, I will make a motion that we proceed with an investigation.
Thank you. Commissioners, we have a motion on the table before us to move to investigate. Any comments on that motion?
And Chair, I would like to know whether the move to investigate is on the basis that there's a subjective or objectively substantial evidence that there was a violation, or is it just a move to investigate further, and is that allowed?
Commissioner Burke, would you like to clarify your motion? If it's one of the standard motions from the manual, we're happy to provide that for you or to read it and you can confirm it or not.
Right. Okay. Thank you very much. I've read the material in the book. I've listened to everyone, and what I see is a lot of smoke. I don't see a fire. I don't see a smoking gun, but I see, some smoke here. Discussion about
Commissioner Burke. I'm sorry to interrupt. I was just wondering are you clarifying your motion? I'm just trying to understand
I was trying to answer the question that I am not saying let's investigate for the sake of investigating and see what we can find. What my motion, the spirit behind my motion is that we find out definitively through an investigation whether or not the charges made in the statutes which are being applied to those charges have any grounds or not. Based on what I've seen so far, I'm not certain about that, and I want to find out.
Thank you. Would it be fair to say that you are moving the commission to find there is a substantial objective basis for believing that Governor Kotek may have violated the ORS and that the commission should expand its investigate accordingly? Is that a fair summary of your motion?
Commissioner Burke, this is Mr. Piscom. There's no trap there. And the question, the chair was simply reading motion number 4 on our category of motions. And if you want to move to investigation, those are the words that we're advised to use in making such a motion.
You're on mute in case you're speaking.
I said yes, then I would use those words.
Okay, thank you. Commissioners, we have before us a motion to investigate. Any comments on Commissioner Burke's motion, which is the standard number 4 motion to investigate from our manual? Okay. Seeing none, I'll make a comment. You've already heard from me already. I guess ultimately, my position on this, and I'll be voting in favor of it, is that I think that moving to dismiss now would be premature and would be treating Governor Kotek differently than we have treated other respondents in very similar circumstances. And for that reason, I want to remain consistent and I want to be thorough, as Commissioner Thompson said. And that's my comment on Commissioner Burke's motion. Any other comments? Seeing none, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
No.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCully,
No.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion failed 4-4.
Commissioners, there's required to be 5 votes. I note that we're missing 1 today. So we're 8-8. We're tied on that, but there needs to be 5 for a motion to pass. Motion has failed. Any other motions that anybody wants to make? Seeing none, we're done with that. Okay, commissioners, I see that it's 11 o'clock. We have, and thank you for being with us today, Mr. Johnson. We appreciate you being with us today.
Yeah, well, it's a pleasure. Thank you for all of your service for the state of Oregon. Appreciate it.
Yeah. Thank you.
Can we clarify that
Yes.
it's an administrative dismissal?
Yes, yeah, I want to make it clear, especially for the media. The vote was 4-4. We need 5 votes in order to pass a motion that was not obtained. And consequently, the motion to investigate failed, and therefore the matter will be administratively dismissed. Thank you. Okay, commissioners, it's 11 o'clock. We have 3 more matters to hear in executive session. We could plow forward. I'd assume that would take 10 to 15 minutes, or we can take a quick 10-minute break. We have a strong opinion.
Let's plow forward.
Sounds good. Let's plow forward. Okay, thank you. Next on the table is Christine Hayes.
I go in the room now.
Ms. Hayes, thank you for being with us today. Can you hear me?
I can't, I'm gonna turn up my volume.
Great, we can hear you. Thank you.
Right.
All right. So, Councilor Hayes, my name is Sean Lindsay. I'm Chair of the Oregon Government Ethics Commission. Now's the time to have your matter heard before us. What will happen procedurally is Investigator McIntyre will provide a report to us. And then you will have an opportunity to respond if you want. You don't have to. And then we'll make a decision on what's to do next. So with that said, Investigator McIntyre, please.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item 97 is a preliminary review for Christine Hayes, Counselor for City of Rockaway Beach. This complaint alleges that Ms. Hayes may have attempted to use her official position as counselor for Rockaway Beach to benefit the Chamber of Commerce for Rockaway Beach and or her personal businesses. She's a volunteer president at the Chamber of Commerce. At the April 10, 2024 City Councilor meeting, when the council discussed system development charges and the council also allocated grant money to local entities. The complaint alleges Ms. Hayes had a conflict of interest related to these issues as well. So just to be clear, not only is Ms. Hayes a counselor for Rockaway Beach, she is also, as I stated, the president of the Rockaway Beach Chamber of Commerce, and she owns multiple businesses. One is a construction company in Rockaway Beach, and she also owns short-term rental properties in Rockaway Beach as well. The Rockaway Beach Chamber of Commerce is in fact a 501c nonprofit organization, and Ms. Hayes serves the chamber in a non-paid capacity. Commission staff reviewed the video and documentation related to both. There was 2 meetings on April 10th. There was a council workshop meeting followed by a regular counselor meeting. They did discuss system development charges, which are fees that are implemented on developers in order to pay for local infrastructure. At the regular meeting, the council did end up voting to conduct a study and report back to the council with the recommendations on potential changes to those system development charges. However, this does not give rise to a conflict of interest, as the decision to conduct just a study itself would not and does not financially impact Ms. Hayes' construction company or her short-term rentals, and nor would it impact the Chamber of Commerce, even though that's not totally relevant because the Chamber of Commerce is a nonprofit organization where she does serve in an unpaid capacity. Therefore, that would not be considered a business with which she is associated. Second, regarding the allocation of grant funding, the council did vote to award grant money to the Chamber of Commerce for 3 things. So it did look at whether or not those 3 things she voted on that could go to the Chamber of Commerce then could be allocated in some way, impact one of her personal businesses. One was to pay for advertising for the Chamber of Commerce, which is not going to impact her personal businesses. The second was to pay kite flyers for lodging and meals. Ms. Hayes is not a kite flyer herself, so that would not personally benefit her. And the third was to pay items to improve the Thursday market. So once again, that also would not financially impact her businesses or her short-term rentals. And because of all these reasons, the specific items that the council did vote on aren't connected to herself, not connected to her businesses. The recommendation in this book, based on the information available in the preliminary review, is that it does not create a substantial objective basis to believe that she did violate any Oregon government ethics laws and should be dismissed. Thank you.
Thank you. Commissioners, any questions for Investigator McIntyre? Seeing none, Councilor Hayes, now's your opportunity to respond if you want. I always do like to remind people that the recommendation is that we move to dismiss it, and you might not want to talk yourself out of that, but that's your call. Here.
Believe folks that are working on those
Present.
things or know that they're not valid, unfortunately, and I wish there was something we could do about that. So I agree with the report that you gave and appreciate your time. Thank you.
Thank you. Commissioners, any questions for Councilor Hayes? Seeing none, Vice Chair Fiscom, you have a motion.
Mr. Chair, I do. I move the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Christine Hayes has violated provisions in the government ethics law or warrant further review, and that this complaint be dismissed.
Commissioners, any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Agenda items, and Ms. Councilor Hayes, thank you very much. It's been dismissed and you'll get confirmation from staff.
Thank you. Have a lovely day.
Thank you.
Bye-bye.
All right, we'll now allow in agenda items 98 through 104. They're in, they're all attending via Teams, and they have all waived confidentiality.
We only have one so far. I know some of them are meeting from the same room though. So
Okay.
perfect.
All right. All right. Well, hello there. Welcome to the Oregon Government Ethics Commission. My name's Sean Lindsay. I'm the chair of the commission. And now is the opportunity you've been waiting for a long time in the waiting room for. Now is the opportunity to have your matter heard before us. And the way this will happen procedurally is our investigator Fenstermaker. Did I say that right?
Yes.
Okay, thank you. Will be reporting to us. And then after that, you will have an opportunity to speak if you want. You don't have to. And then the commission will make a decision upon the matter. So with that said, Investigator Fenstermaker, please proceed.
Great. Thank you. Good morning, Chair Lindsay, Commissioners. For the record, my name is Casey Fenstermaker. Items 98 through 104 in your meeting books are preliminary review reports for the members of the Town Council for the Town of Butte Falls. The complainant in this matter asserted that the Town Council violated public meetings law. First, by failing to hold a hearing, he requested an executive session. And second, by amending the meeting agenda without notice or vote. With respect to the demand for a hearing and executive session that was denied by the Town Council, the Town of Butte Falls, as a governing body, has the discretion to hold an executive session under the public meetings law, but is not required to do so. That interpretation is supported by the administrative rules as well as the AG's public records and meetings manual. With respect to the complaint regarding amending the meeting agenda, the governing body must provide for and give public notice that includes a list of the principal subjects anticipated to be discussed at the meeting. However, there is no prohibition on the governing body changing the agenda to either add topics not previously listed on the agenda or to remove topics originally listed on the agenda. Therefore, there's insufficient information to conclude that the Town Council violated the public meetings law during its February 28th, 2024 meeting. The reports included in your meeting books recommend that each of these matters be dismissed.
Thank you. I appreciate it. And also welcome to the commission as well.
Thank you.
I gave that to Investigator Sullivan, but not to you, but we met beforehand.
Yes, thank you. I understood it.
We really appreciate you being with us today.
Thanks.
And bless you. All right, commissioners, any questions of Investigator Fenstermaker? Seeing none.
None for the Town of Butte Falls.
Thank you. All right, Mayor Callahan, now is
Yes.
your opportunity to respond if you want. But again, as I mentioned to some folks, the recommendation is to move to dismiss. So you're welcome to speak, but you might not want to change our minds.
Well, I appreciate you taking your time out to be able to review this. I know that I speak for my council members that were not able to attend today due to their jobs or medical issues. I just want to say that we appreciate that you're finding and to possibly dismiss this case. We really appreciate that. We try to make sure that everything that we do as a council and as mayor is that we have the most recent and correct information that we try to supply to the people that attend our meeting and for everybody involved. So just thank you for listening today.
Thank you. Thank you for being with us. Commissioners, any questions of the respondents? Seeing none, Vice Chair Fiscom, do you have a
Mr.
motion?
Chair, hereby move the commission find that the complaint information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Ms. Trish Callahan has violated provisions in the, which category?
Public meetings.
Public meetings law. Thank you very much. Thank you. Or warrant further review and that this complaint be dismissed. Thank you.
Thank you. Commissioners, seeing no comments, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley, Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Chair Fiscom.
Mr. Chair, I hereby move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Keith Gillingham has violated provisions in the public meetings law or warrant further review and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Chair Fiscom.
Mr. Chair, I hereby move that the commission find that the complaint information available during the preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Ms. Peggy Davis Gilliam has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Commissioner Burke.
You're on mute. Thank you.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Go ahead.
Mr. Chair, I hereby move that the commission find that the complaint information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Paul Price has violated provisions in the public meetings law or warrant for the review, and that this complaint be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCully.
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Chair Fiscom.
Mr. Chair, regarding item number 102, I hereby move the commission find that the complaint information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Alvin Thompson has violated provisions in the public meetings law or warrant for the review, and that this complaint be dismissed.
Seeing no comments, we will call for the vote.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Chair Fiscom.
Mr. Chair, I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Delina Oden has violated provisions in the public meetings law or warrant for the review, and that this complaint be dismissed.
Thank you, and we will call for the vote.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully. Aye. Chair Lindsay.
Aye.
Motion passed 8-0.
And Mr. Chair, I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Stacy Equitz has violated provisions in the public meetings law or warrant for the review, and that this complaint be dismissed.
Thank you. No comments, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke.
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. All right. Well, thank you, folks. Thank you for being with us today. It's been dismissed, and you'll get confirmation of that from our staff, and we wish you a good weekend.
Mr. Chairman and the board, thank you very much for your time. We really appreciate that. And you guys have a nice weekend also. Thank you. Bye.
Bye. All right. Our final executive, my brain's fried, executive meeting. There you go.
Session is the word.
Executive session, there we go. Sessions. It will be agenda item 105, and we're letting in